Well, thank you. Good morning. Welcome to this panel organized by the Chair in Law and Human Genome Network of the University of the Basque Country. My name is Pablo Rodrigo Kramchak. I'm a legal researcher at the Cyber Data Security Lab of the Free University of Brussels. I will be the moderator of this session. We tend to speak of the European health data space as a regulatory achievement, and in many respects, it's one. That said, it's worth pausing on what the regulation actually delivers at this stage. It entered into force in March 2025, but will not generally apply until 2027. Its secondary use provisions will only become operational from 2029 onwards, and implementing and delegating acts that will determine the framework's real operational content remain to be adopted. So this morning, we are offering a we're not offering a backward-looking analysis of a finished legal instrument. We are engaging with a framework that is still under construction. Four main questions will structure this discussion. First is about the role of the European Commission. The Commission must build and operate cross-border infrastructures for secondary uses, while also defining the technical standards that the entire system depends on. So the same institution is in some way asked to wear several hats at once: infrastructure operator, standard setter, and coordinator of national health data access bodies. Second, how the technical instruments, infrastructure, including secure processing environments, will reflect the governance model conceived in the European health data spaces. And third, standards. The interoperability architecture of the European health data spaces rests on technical specifications that are still being written, and they intersect with the AI Act, the Medical Devices Regulation, and of course the GDPR. And finally, supervision. Different bodies operate on the same data flows, each with its own mandate, legal framework, and institutional culture. So the supervisory landscape, of course, is very complex. The concern then is not simply duplication of effort, it's the risk of contradiction. So these concrete challenges of a system still of construction will be analyzed in this panel. These are the questions this panel or speakers will take up. So let's begin. We will start with Owen Langfeld. He's a policy officer in the Digital Health Unit of the European Commission, DG for Health and Food Safety, focusing on the European health data space. Earlier, he worked in DG for Justice and Consumers in the Data Protection Unit, particularly on digital single markets files, health, and home affairs. And before joining the Commission, Owe was a legal officer in the Supervision and Enforcement Unit of the European Data Protection Supervisor. So, Owe, thank you very much for being with us today. The floor is yours.
Yes, thank you for having me, and good morning. I see you all grabbed your coffee if needed, so that's good. Let's... yes, the other green button. Yep. Sorry for that. At least I blinded nobody up there. So, yes, I'll start here with the... Well, I'm not going to go into the general overview of what the EHDS does. I'd say that's a bit more, it would be a bit too basic for this panel. But still, just as a reminder, so we have common European rules on who has to make which data available for secondary use for certain defined purposes. And we also have a kind of governance framework around it on how that will work. So it's not just, here are the data, have fun with them, but there will be a whole process with the vetting of the applications by the health data access bodies. And a bit closer, I've been told. Sorry for that. So the process of vetting the applications by the health data access bodies and so on, making them available in a secure processing environment. There will also be common infrastructures that Pablo already alluded to, the health data at EU infrastructure, and the data catalogs. So what I've been asked to talk about was then a bit more on what does Okay, okay, you can see it here. It's a bit patchy, but fine. I think I should remember my own slides. So I'm still gonna put them up here to help me a bit. Sorry for that. So as Pablo also mentioned, well, we have kind of two different hats here. One on the regulatory side. So the EHDS, while it is a pretty long text at 105 articles, still leaves some things for more detailed documentation and basically implementing and delegated acts to flesh out some of the details. That was one of the choices made at the kind of preparation of the proposal, and also then the co-legislators were okay with that. So on these adopted so far, we only have one. That was on Article 92 on how the EHDS board will work. That was in a way also our test balloon with the committee of the member states. I'm not going to go into comitology, but the short version is that for these implementing acts, we're working with the committee of the member state that basically needs to give us a thumbs up on the draft implementing act. You may also have seen that we've had some of the recent public consultations running, public feedback mechanisms, sorry for the phrasing, running through Article 16, My Health at EU. Article 16 was identification management for primary use. 23, My Health at EU, so the infrastructure for primary use. And 77, the data set description, so one on secondary use. Their work is ramping up. So as you may also know, we have a deadline of March 27 to adopt quite a few of the implementing acts. That is basically so that the first 2 years preparation, setting out the details of the blueprint, and then the 2 more years until 29 to actually then implement it, so that by 29 everything is ready to go. Think like, well, we're going to hear more about secure processing environments later. Some specifications for them will be in implementing acts, and between the time that these specifications will be adopted to 29, where somebody actually needs to set up these things and build them. So that's what we're doing on the regulatory side. Then with the other hat, the operational hat, we'll be running the health data at EU infrastructure. I'll be going into that in a bit more depth in a moment. As Commission, we'll also be operating the Union Health Data Access Service, which is basically the functional equivalent to a health data access body for relevant data held by the EU institutions themselves. And finally, we'll be setting up the EHDS board and the stakeholder forum. The provisions related to those two bodies will come into application in March 27. So one of the earlier bits on the entry into application. For the board, member states will simply designate their representatives, while for the stakeholder forum, we'll be doing a call for applications and then selecting stakeholders in an open and transparent procedure. So that is something to expect, let's say, towards the end of the year, that call. Now, in a bit more detail on... Yeah, I forgot that there were too many animations on this slide, so I'm just going to click through here until I get to the one that went too far. So on what the Commission will do and what health data at EU will do. One important thing to remember is that it actually doesn't do that much. It's not the a central European data lake. It is, in the end, very limited. It does two main things. It will federate the national data set catalogs set up by all the different HDAPs around into a European catalog, where then researchers can see the data set descriptions all in one place. Function 1. Function 2, they will also be able to apply through there, and then this infrastructure will dispatch the applications to the relevant health data access body. The competence of the health data access policy is always linked to where the holders are established. So if you want to get data from University Hospital Leuven, you will have to go through the Belgian HDAP independently from, let's say, where you are applying to. So in that sense, yes, it's always linked to the where the holder is established. So there's no going around saying, so, oh, if I go through this HDAP, I get to those data maybe a bit easier. No, it's always linked via the establishment of the holder. That was one thing. Yeah. It's too much power saving going on here. Then one thing where, this links back to the secure processing environments, normally they are supposed to be provided under the control of the HDAPs, but for the kind of cross-border or multi-country cases, there is also a possibility that the Commission, as a basically service provider to the HDAPs, would provide a kind of pan-European SPE. That is kind of what we're doing there on the operational level in Health Data at EU. One step back maybe on the GODAS, so the European Health Data Access Service, that is yes to be set up inside and by the Commission, so that is also still in process. What more can I say here? Maybe two final things on the, let's say, sustainability or how things will work in the longer run, because yes, there are costs for the different actors involved. So who and how is gonna pay for that? There can be fees linked to the applications and the permits. They are supposed to cover or to address things like, well, the cost of providing the SPE, the cost of the operations of the HDAP. There is also a part of the fees, which would be charged by the Health Data Access Body, that can get funded back to the holder to basically compensate them for the work in extracting the data needed for a specific permit. This feeding back to the holders is for that part only. It's not for, let's say, the work needed to provide data set descriptions to be included in the catalog. That is simply a reporting obligation imposed on them by law. Yeah, that is a bit of an overview of what the Commission will do here. I see Pablo is already giving me a sign. There are just a few seconds left. But yeah, just with this overview, I will conclude here and yield 20 seconds of my time. 15.
Okay, thank you very much, Owe, for your presentation. Of course, we're going to delve into some of the aspects you covered during the Q&A part of the session. And let's address now the second question of this panel on secure processing environments. Federica Casarosa is joining us today. Federica holds a degree in private law from the University of Pisa and a PhD in law from the European University Institute. Her work is focused on the role of information in consumer contracts, the protection of personal data of consumers and internet users, and the implication of cybersecurity regulation for private law. She has also developed extensive experience in training legal professionals, having served as scientific coordinator of several training projects led by the Center for Judicial Cooperation at the European University Institute. So, Federica, thank you very much for joining us. The floor is yours.
Thank you so much. I hope you can hear me, and thanks for being so early risers to come today at this unlawful hour for having presentation. I'm Italian, and I can tell you that this is not the right time for being awake. So so my point will be following up what Owe was mentioning early on, is to look upon what has been the connection between the legal and technical requirements. In particular, looking at the technical infrastructure that has been set up by the European Union as regards data spaces, because we have to think that European Health Data Space is one of the 14 data spaces that has been set up, and that's the strategy in order to look upon how they can not only work autonomously, but they can also have been interlinked among them. So this is important because the idea is to have a decentralized structure where the data can flow. Decentralized is a kind of, let's say, misleading approach, because it's not exactly so decentralized, because as the presentation was mentioning earlier on, the centralization element is still present. So we will have European at EU as a cornerstone of this structure, while all the other national databases will be, let's say, feeding their data on. So it's a kind of, let's say, structure that is still, let's mix up this two perspective of centralization and decentralization. And the cross-border, of course, will be the infrastructure as health data at EU. But one of the things that is, let's say, important to look upon is that lawyers and legislators, are not technical or computer scientists. So they have to set up some kind of legal requirements that has to be translated into technical requirements. And this is not an easy task because, of course, the architecture means that you have to comply with some set of rules that have to be implemented through limitation or conditions to the ways in which data can flow. And in this sense, let's say, I hope you can see it well. This is an image that I take from one of the few projects that has been devoted to the, let's say, to the implementation of the European Health Data Space architecture. You see that there are several nodes that will be addressing at national level the data processing, and so the collection of the data, the cataloging, and then after that, get into the health EU at EU system. And then the data user will have the possibility to ask a permit to the national health data access body in order to gather and to be able to use the data available. So this is exactly the secondary use of data. But one of the things that is important is the fact that we are speaking about health data. So these are sensitive data. And so the issue is that how do we transfer or access, there has been a colleague of mine that has been working as a PhD thesis between these two terminology. What is access is what is transfer. There are a very difficult distinction between the two, because of course you can access data, but as soon as you access them, you can also have a copy on your computer that can be further on used. But in this case, this is not what the European Health Data Space wants to do. Wants to keep the possibility for the, let's say, in particular, non-anonymized data to be kept safe and safeguarded according to the GDPR principles. So in that sense, what is happening here? We put the secure processing environment. So the technical structure where the, let's say, the processing, the activity, or the games, or the activity, sorry, the nerd work of computer scientists will be working, is there. So how do the data users will work and access, work, and then get out some outputs is the secure processing environment. And how does it work? We have the definition that comes from the Data Governance Act that will be probably dismissed in terms of a single regulation from the Digital Omnibus, is a controlled physical or virtual environment that allows authorized users to analyze data while preventing unauthorized disclosure or extraction. Okay? This is exactly what the GDPR principle. So you want to use the data, you want to process them, but you don't want to have them getting out for further use. So it's a secondary use, but it's just limited to the one that is authorized by the data permit. So, but in this case, it's not just saying that, you know, it's technical artifact. It's a process. You have to get in, you have to work, and you have to get out. So in this sense, the type of activities, I'm sorry, I'm putting too much words on a single slide, will have a set of steps that are the authorization and acquisition plus the data preparation and centralization are usually the part at, let's say, the design part that comes from the health data access body. But then within the secure processing environment, we have the controlled access provision. So you will have to be authorized to get in. Will have to be selected. We will not have the possibility to say, you know, this is my team, all of them will get access to the secure processing environment. This is not the case. It will be just single individual access provision for each of the people that will be getting inside. There will be a role and permit. So what can you do? It depends on the type of software that you want to use. If it is available, there's a control over what is being done in terms of use and analysis. And then what is coming out is not the data. At least this is what has been said. So it's not the personal data, it's the output of the analysis. So the data per se will not be getting out from the secure processing environment. So this is the structure that we want. And so we can see that the secure processing environment is not just technical. It's a kind of a legally enforceable gatekeeper. So it's a structure that will end up in limiting not only the possibility for the users to get in and authorize, but also the type of work that the data user can do within the secure processing environment. So it's a kind of control over what has been done in terms of activities. So what are the open issues here? First of all, who is going to set up the secure processing environment? The national health data access bodies. This is what has been said, at least in terms of, let's say, the public secure processing environments. Because we want to make sure that each of the countries will have their own, let's say, public-based secure processing environment. But the regulation does not exclude private ones, but we will get there. So we need, first of all, high level of expertise and organizational capacity. We have 27 member states, different level of financial support to this type of activities. So it's not that easy to get to the same level and the same structure in terms of uniformity across the member states. Then we have a risk for institutional self-review, meaning that each authority may decide how the secure processing environment will be set up, the safeguards, the choices regarding the responsible assessment of the adequacy, also ex post. So let's say that I set the rules and I control if they are working. So it's not that easy if you have, let's say, possible risk of impartiality, reviewability, and let's say judicial oversight. So if I'm the one that set up the system, I'm saying that the rules are corrected, are complied with easily if I'm not really sure, even if I'm not really sure that this is the case. And then there's a limited, there can be some kind of limited transparency also outside the secure processing environment infrastructure because, and in that sense, of course, it will be up to each national data access body to provide information and explaining which are the safeguards, the thresholds, the refusal that were chosen in a given case. So it's a kind of, let's say, easy task to solve this problem, but still we have to, let's say, take that into account. Another set of issues are when the secure processing environment is going to be set up by private parties. So on the market, there will be, and there are cases already available. If I remember well, there's a German one that is already working, that will be secure processing environments set up by private parties. So the national health data access body will be still controlling, having the control of the infrastructure, but the design and incident response will lie on the private operator. It's a different problem from the one that is in the public secure processing environment, but it's but there's still a problem there. It can be there because, of course, the responsibility can be diluted. So who is going to be blamed if something happens? Is it going to be the health data access body because it had not monitored enough? Or it will be just, it's the private party that has not done the work correctly. So it's and in this case, last but not least, the possibility to delegate the choices on the technology may allow the private parties to decide what is going to be done rather than being set up by the public actor. And in this sense, one of the important elements that I think it's really relevant is what you were mentioning earlier on over regarding the delegated acts and acts that will be coming from the Commission regarding what are the, let's say, the basic elements, the basic requirements that a secure processor environment will have to have in order to make sure that we have an harmonized system across Europe that can be, let's say, implementing this set of legal requirements into the technical infrastructure, and at the same time providing an alternative that is the European one for the cross-border cases. Because, of course, this is something that will be, let's say, making as a template for the national ones. I think it would be a very interesting, let's say, if the Commission is going to be working hard in order to set up this European one, will be, let's say, the template or the structure upon which looking in order to set up the national ones. And on this, I finish up. Okay. Before you even...
No, don't worry. Thank you very much, Ferriga, for your very, a lot of information that you just provide. We're going to delve into that later. Don't worry about this. So now, what role will standards play in the European health data spaces? So Francesca Tassinari will address this question. Francesca is a research fellow at the Department of Public Law of the University of the Basque Country. She holds a PhD in Public International Law and International Relations at the University of Granada and in EU Law and National Legal Orders at the University of Ferrara. She worked at the European Commission between 2020 and 2023. And Francesca, please go ahead. The floor is yours.
Thank you, Pablo, and happy to join discussions together with wonderful colleagues that preceded me and also the one that will follow me. Yes, that's actually, I will be happy to work a bit on standardization and the magic word that have been, let's say, ghosting me for several years, which is interoperability. And the main goal is to present you what standardization is in international and specifically EU law, what standardization means both in primary use and secondary use, but in order to actually shed light on the cumbersome and difficulties that will come from standardizations and interoperability in secondary use under the EHDS, to make some final critical observations. So first of all, it is important to make a distinction between standardization and interoperability. And when we talk about standardizations, we talk about adherence to product or services specifications. Standardization in general should not be seen as a synonymous of quality unless actually high quality is specified. And it is perceived, at least by the international standardization organizations, as a purpose, let's say, oriented definitions, which is the following: documented agreements containing technical specifications and other precise criteria for consistent use as rules, guidelines, or definition, with the objective of ensuring that materials, products, processes, and services are fit for their purposes. So this means that actually when we talk about standardization, we're trying to adopt a finalist and a siloed approach for which each product or process must be fit for a specific goal. Conversely, when we turn to interoperability, we can see it is a part of standardizations. Interoperability is the ability of two or more systems or applications to exchange information and to mutually use the information exchange. This is given by ISO, but we also have a lot of already instruments adopted at the EU level that talk about interoperability. EHDS itself provides us with a definition of interoperability as the ability of organizations as well as of software application or devices from the same manufacturer or different manufacturers to interact through the process they support, involving the exchange of information and knowledge without changing the content of the data between those organizations, software, applications, or device. So we can say that interoperability is actually a characteristic of the product, which it should be envisaged by the design of it, and it encompasses at least 4 dimensions plus one, which we would add the legal one actually, that has been, it is of particular interest for me and for us as a lawyer. The EHDS actually give us some, the 4 dimensions of interoperability are technical, semantic, syntactic, and organizational interoperability. EHDS itself gives us some example of what interoperability is. For example, in terms of semantic interoperability, we are talking about the ability to share the information and understand. So we need a sort of contextualized informational sharing background, and in this sense, the HDS will help, for example, doctors or healthcare practitioners from different member states in order to understand each other and prescriptions and how to act in this sense in order to provide healthcare. While when we turn to, for example, syntactic interoperability more technically, it concerns the possibility to transform and technically transform the information that is being shared. For example, in the case of the European electronic health record exchange format that enable the sharing of information with automated translation. So just to quickly understand, when in standardization at the EU level is usually mandatory, it could be delegated to European Standardization Organization, which is not the case under the EHDS, that is mainly held at the Commission's level, and it is generally identified through the adoption of technical specifications that need to be complied in order to let's say to play in the EU market. When we turn to the analysis of the of standardization for primary and secondary use of health data under the EHDS, just to let you know that we had already a previous legislation like paving the way through actually standardization, at least for myhealth.eu, so the sharing of information, health data for primary use under Directive number 24 of 2011 that introduced the voluntary e-health network under Article 14, but this was only limited to electronic prescription and patient summary records. It was a bit extended through a recommendation of the European Commission in 2019 that introduced the European electronic health record exchange format, and now it became mandatory. It is becoming mandatory under the EHDS regulations that transform this voluntary framework to binding obligations. So myhealth.eu, as it has already been mentioned by my colleagues previously, becomes mandatory, and also common specification adopted, which will be adopted through implementing acts. In terms of primary use then, to be more concrete, the standardization and interoperability is realized, thanks to the adoption of the European Electronic Health Records Exchange format under Article 15, based on the previous recommendation of 2019, and the technical specification of the European Commission. This implies what they need to exchange at least the priority categories of personal electronic health records established under Article 14, which you can see listed there, that member states can complement through the adoption of additional categories of personal data. And the mechanism is, it is well established under EU law, also through market law and trade law, because it concerns both for electronic health record systems and wellness application. It imposes to the manufacturers of the products, of the system or the applications, to make a declaration of conformity in order to prove compliance with EHDS requirements, and thus a declaration also of interoperability that makes the systems or wellness application fit for sharing these categories of data. And in case of certified EHR systems and those wellness applications that are labeled by the own manufacturers, then we will find all this information in the EU register that the Commission has to also elaborate through delegated act under Article 49 of the EHDS regulation. The logic, the rationale is completely different when we talk about secondary use of health data, because in this case we have no standardization foreseen at the EU level. The regulation states that data must be accessible, high quality, ready, and fit to create scientific, innovative, and social value and quality as possible. So, as a general rule, when we talk about the use of data for secondary purposes, the secondary purposes that are listed under Article 53 of the EHDS regulations, we have instruction on the fact that that data must be made available, preferably in a structured electronic format, facilitating machine processing. But we have no standards that are going to be envisaged at the EU level. The categories, moreover, must be broad and flexible to respond to evolving needs, but limited to data related to health or whose influence on health is known. Recital 56 of the EHDS regulation. What does it mean? That we have an harmonization gap, many data sets actually for secondary use, because in the case of secondary use of health data, we are not dealing only with electronic health data from the electronic health record system, but more categories of data. This means that we have not harmonized and standards for sharing this type of data, and this implies compatibility problems which might hinder cross-border sharing of data for secondary use. This should be addressed, at least partially, maybe Owe can correct me later on, by the Commission through the adoption of an implementing act. But again, that implementing act will only foresee the yes, these were the list of data that is contemplated for secondary use. But the implementing act itself will not actually, I'm finishing, yes, will not actually foresee will not establish, okay, the quality of the data, but only the, let's say, its categorization. In this sense, and just to finish, Article 77 and 78 become relevant for the establishing of a dataset catalog and the data quality utility label. These have been partially mentioned before. While the dataset catalog is responsibility of health data access body to provide, let's say, and to make public the list of data that are available and describing some specific characteristic, the data quality and utility level might be appointed and made established by the health data holders. And this also is only mandatory in case of health that are processed and used with public funding, but not by private one. And just to finish then, as you can see, the procedure for standardization and interoperability, I know it's quite technical and sometimes difficult to grasp for myself itself as well, is very difficult for primary and secondary use and might imply more cumbersome and more problems for the establishing of standards for the secondary use of health data.
Yeah. Thank you very much, Francesca, for raising all these issues on standards. So we're going to, of course, delve more into that during the Q&A part of the session. Finally, who are we going to ensure that supervision is not repetitive and contradictory? Well, it's a big question here. And for addressing this topic, we have here with us my colleague Anastasia Kiseleva. She's a postdoctoral researcher at the Free University of Brussels, affiliated with the LSTS Anti-Health and Aging Law Lab. She holds a dual doctoral degrees in law and computer science, and her work lies at the intersection of AI regulation, health law, transparency, accountability, and socio-technical governance of emerging technologies. So, Anastasia, please go ahead. Thank you very much.
Thank you very much. Oh, wow, it's quite loud. Thank you, Pablo. Thanks also to my co-panelists for very insightful presentations. It's a great pleasure to share the panel with you, and I'm very much looking forward to the discussion. I don't have slides, so unlike my co-panelists. And I will just go straight directly answering the question. By phrasing the question, we can already guess that there is a probability that there is a lack of there might be repetitions and there might be contradictions in the bodies. And to answer like how we can actually ensure that there is nothing there yet, I will first describe the issue. I will first describe being inspired by one of the workshops from yesterday about the secondary use of health data. We imagine that the AI developer tries to get access to the secondary data. So now I'm going to also create this scenario that AI developer following the compliance route. And we will see also how many bodies this AI developer is going to face directly or indirectly. And by describing that, I think it will be actually quite clear, if it's even possible, to avoid contradictions and repetitions. So first, the main framework, this medical devices framework, there is conformity assessment procedure for an AI developer, because AI application in medical field is software and medical device. So there is conformity assessment procedure. The body is notified body, that's like third-party commercial company that oversees and controls conformity assessment. Then these notified bodies are also regulated by national competent authorities. And there is also the group, which is called Medical Devices Coordination Group, which oversees all and issues guidelines for all the notified bodies and also for the developers of medical devices. And there is even also like the coordination group between notified bodies. So it's 4, directly or indirectly, that AI developer faces only for one framework. Then, of course, with the AI Act, we have now the new set of rules that also medical developers of medical devices with AI component have to comply with. Luckily, within one procedure, but still there is also 2 bodies involved in that, at least. National Notifying Authority that is going to check if notified bodies that control developers of medical devices are ready to check the conformity with the AI Act, and also the AI Office overseeing overall. So it's 2. And then imagine that the developer also wants to get access to the data from the European Health Data Space. Then they go to the Health Data Access Body. That's +1. Then we also, for the developer would also like to actually show the conformity and interoperability with the EHR system, even though it's voluntary. But of course, like every medical device manufacturer would like to show that compliance, because no hospital would use this medical device if it's not interoperable with this. So that's +2, and then we also have the EHDS board and the commission +2. And of course, no like medical device application without data use, right? Personal data. So we also have data protection authorities and European Data Protection Board. So overall, I calculated, maybe I miscalculated, so you can also correct me, but overall it's 12 bodies that are involved in this process that a manufacturer of a medical device should face directly or indirectly. And let me remind you that one of the purposes of all the legislation in digital domain is to boost innovations. It's quite contradictory, even when we also imagine that a manufacturer, innovator, should actually go through all these just to issue their innovation on the market. I made it on purpose quite scary and quite like big to describe. Of course, the real picture is not like I described. AI developers face only directly, they face only four bodies. Notified body, health data access bodies, digital health authorities, and if they are not very lucky or they are not compliant, data protection authorities. So it's only four. So we can only also guess here that the coordination issue is not on the level where AI developers face bodies, but the coordination issue is on the higher level of the authorities that oversee all of those low-level bodies. And yeah, there are some mechanisms also in the laws that actually see like the coordination, like they said that, for example, the AI office should coordinate with the medical devices coordination group to set common standards and so on, so on. The EHDS boards also should cooperate with the AI office and so on. But in practice, well, we also should understand that now it's like that the legislation itself or the implementation of the legislation is in its infancy. So it will be also very difficult to foresee how to actually coordinate, because 12 bodies, they're also from different institutional frameworks. There are many different legal frameworks, local differences. So it's going to be for sure the challenge to coordinate all of that. And on top of that, the real picture is that, for example, the coordination between the medical devices regulation and the AI Act. Up to now, there is information that the currently existing notified bodies that foresee, that control the manufacturers' medical devices are not ready yet to check the compliance with the AI Act. So the medical device manufacturers are in the position that actually they are ready to comply. I talked to several manufacturers, like big companies. They're ready to comply. They're ready, like, also to implement, because they also kind of like was following very similar rules before even the AI Act was adopted, because also the AI Act was inspired by the medical device framework and product framework. So they are ready, but the bodies that they're going to check their conformity assessment, they are not ready. And this is also because of the lack of the skills and so on, of the staff and so on. So yeah, answering the question, one way is to streamline compliance on the low level. For example, if, for example, the manufacturer uses the data from the European health data space, this data is of a good quality, right? Because there are standards for the accuracy and quality of data and so on. One way also that this information could be also used to check, to show compliance with the data governance requirement of the AI Act and the medical devices regulation. So that actually it's also easier if they follow all these rules, they can also connect the dots and show all the bodies, like how all this connected and how it's all, how the compliance with each of the frameworks facilitates compliance with another framework. And the second way of coordinating and avoiding repetitions and inconsistencies is to facilitate the coordination on the high level, setting the same standards as you were describing, and standards itself is a very difficult issue. Setting the guidelines, setting also well, understanding how to avoid the overlapping of expertise and overlapping of the staff using the same resources to check the same set of requirements. And yeah, the coordination of the AI office between the EHDS boards, the coordination between the AI office and the medical device coordination group, and facilitate the standards, because that's the main tool to, I'm finishing, thank you. That's the main way to actually streamline compliance and implement all the frameworks. Thank you.
Thank you very much, Ansia, for your presentation. Well, we are going to cover, of course, more in depth this during the Q&A. So I will start with first short question to the speakers related with some aspects that probably were not totally covered during your presentations. I would like to start with Owe regarding the issue of fees. So we need to have this balance between those fees and access. And particularly, thinking about the situation of smaller researchers, small research actors, how to balance this? I don't know, how do you think that we should cover this aspect that is not solved in the regulation, in the text?
So the basic question of who's going to pay for this? So what I mentioned briefly in the presentation was, yes, there's a possibility to charge fees. The fees can go up to cost recovery, but let's say below that threshold, the HDAPs have some flexibility. The fees need to follow a transparent, fair, and comparable process, so they cannot charge to similar types of users widely different amounts for the same work. But what is explicitly acknowledged is, for example, that there's a possibility for, maybe this is of interest for some people here in the room, what we colloquially call the academic discount. That, obviously industry and academia have different financial means at their disposal, and allowing kind of reduced rates for academic researchers or SMEs, that is explicitly already recognized in the text. Now, to spell that out a bit more detail, there is, you guessed it, an Empowerment for an Implementing Act, Article 62, for the Commission to set out fee policies and structures. So we're not setting the rates or the fees, because that will depend on many things, but we will be providing, let's say, a general framework of what can be charged, how do the different elements relate. That should lead to a level of convergence in the fees charged. I can also just say that during the negotiations, this was something that came up again and again, and that the member states were, of course, also keen to leave some margin of discretion for the HDAPs here.
Okay, thank you. Thank you very much, Owe. Federica, regarding the secure processing environments, you mentioned some risks you can envision regarding the application of this system. So can you, when applied to for example, cross-border research, how can you give us some examples of some bottlenecks you can, an exercise of prognosis, what we can expect,
Okay, so looking into my crystal ball, I can tell you that I see some potential problems. Let's say that in the cross-border environment, it will be first problematic because one of the things that who is going to be, let's say, is it a transfer from the health data access body that goes to the national data access body that is in the member state of the requester, so the data user? And in that sense, which will be the secure processing environment? What if the level of protection is different from the secure processing environment that is in the, let's say, the sending country and the receiving country? In that sense, it's a problem regarding again, harmonization, the same level of protection, but also the technical infrastructure that will be set up. Another element maybe is also the fact that the secure processing environment will have a set of software applications that are available and vetted by the Health Data Access Body in order to be used within this system. What about if I want to try machine learning? How the computational capacity of a secure processing environment in case of machine learning, and eventually for, let's say, activities that are not exactly, let's say, envisaged since the beginning. So there may be risk of subsequent exposure through hallucination of the AI system. What happens there? Do I have the possibility to allow this type of activities or not? Or there is a secure processing environment that is in Lithuanian, let's put it like that. But the database there is not the one that I want. But I want to use that secure processing environment because that's the one that is most updated and has this type of software that I can use. What can I do? Is it possible to go and exploit only one piece of the system rather than asking the data from Spain? I'm an Italian researcher and I'm going to the secure processing environment in Lithuania. The cross-border, let's say, in principle, should allow that, because the idea is that I want to have the data to flow, but at the same time, it will be, let's say, moving the cost of the research in a different way. So imposing a cost, for instance, to the researcher to go in Lithuanian and go and do the work. So there are possibilities, but there are also maybe problems that could emerge in the cross-border context. And in this case, I again underline what Ove was mentioning earlier on regarding the European secure processing environment that could be again, let's say, a jolly or a structure that could help in this type of cases, providing at least a setup that could be moving and let's say providing a template for the national ones.
Thank you very much. Yes, I took a lot of notes around that, so I'm a little bit concerned. Yes, it's a big issue. I think when you're involved in research, of course, is how to deal with these different environments in a safe way. You know, so, still we need to see some implementing acts in order to have more clarity about this. Francesca, the role of private standard setters. You know, a lot of criticism always about this. So in the particular case of the health data spaces, should we be worried about this situation? What do you think? What are you expect with regarding the role of these private standard setters?
Yeah, so actually, I am having a lot of input now that we are talking. Also, Federica, very good insights for. Also, I was also thinking that maybe sometimes we're talking about sharing. I've been talking about sharing, so also the languages could be misleading, no? And I was reflecting about it. And in the case of also interoperability and standards, and this actually maybe I could jump in later on. I don't see direct implication of ESO, European Standardization Organization, but more actually, as I've said before, the border is on the European Commission to adopt technical specifications. There could be an indirect link concerning then the issues related to the AI systems, or but this is because of reference to AI Act and not directly the EHDS regulation. Despite that, it should be seen actually in the comitology procedures whether these bodies could be either informally involved or are involved. And on the other hand, I would say that there is a need also to comply with international existing standards in the sector. And this is, this is an important coordination that actually the EU demands on its standardization strategy broadly, and should be also taken on board sectorally in the health data space concretely. Of course, from my experience, maybe member states, when negotiating the main act, usually pressure a lot, and I had not that much time to say it before, but pressure a lot on competence and try to restrict, maybe, even though the Commission at the beginning, not defending it, but is generally generous in providing services for member states in this case, they might end up member states themselves asking more solution to Commission when they say that they can't manage it at the national level.
Yeah, thank you, Francesca. Anastasia, what do you think about this? Well, we have in EU law this buzzword of coordination when we experience some kind of complicated situation of multiple frameworks operating at the same time regarding the same kind of activity. So in this particular case, I mean, in order to avoid having this ideal of coordination just on something aspirational, what do you think we should do in order to tackle this problem?
Thank you very much. Yeah, I'm glad that I can switch the perspective from the negative one to the more positive one, because my talk was a bit sad. So yeah, I think it's actually like not even linked to the EHDS. It's about, so like not directly the topic of the panel, but it's about the coordination between the compliance in the AI Act and the medical device regulation. Because in the AI Act, there are many requirements that already exist in the medical device regulation. For example, technical documentation, transparency, data governance, but they are read a bit different. And there is like a long history of manufacturers of medical devices, including those that include AI elements, because they were placed on the market even with AI before the AI Act was adopted, and they're still being placed on the market. And again, because I talked to the manufacturers, they were prepared for the AI Act before, and they care about the safety and so on, and they have a lot of requirements that are there in the AI Act. The problem is that now we have like the set of technical standards that we are all waiting for under the AI Act, and then the manufacturers will have to comply with those standards as well. But notified bodies are not prepared for that. And also there is a risk that those standards don't consider the history, the long traditions of medical devices manufacturers of their requirements that are quite similar. So there is overlap in different requirements, for example, like transparency, or for example, data governance. They have like clinical data governance, a long history. And now we have might have a different data governance standard. And there is just one example, and like technical documentation as well, and so on. How to actually make the coordination? I think the industry, also they suggested to exempt the manufacturers from the AI Act. That's quite a bold solution, but it's not coordination. We should involve the manufacturers of the medical devices into also the standard setting under the AI Act, and also the standard settings like MCIN, like they also should maybe consider not only one industry, not only medical devices, but also different industries, because this issue might be also present in different industries. And it's a very challenging task to create the standards that are harmonious across disciplines and so on. So might be as well the like different levels of standard setting. One is very broad level, but then other levels of like industrial specific standards.
Thank you very much. So yeah, I have a follow-up question, but I could give some space for to the audience for asking some questions to our panelists. Do you have okay? Yes, you first. Yeah, you were the first. I remember you. Yeah, you really want to pose questions, so go ahead.
Can you hear me? Great. Hi, thank you all. Farid Masouli, Radboud University, researcher on secondary use in the EHDS. I have a question to O about fees. So you mentioned that fees were just for processing and cost recovery, all of that. It happens that, I mean, I've been working on the EHS for 2 years, so for me it was clear it's not paying to have access to the data. But then last month, a colleague of yours, Guillaume Bic, I think from DG Santé, mentioned something I hadn't heard of, which is the possibility for health data access bodies to clean up the data of data sets that would be uncleaned, unstructured. And again, I hadn't heard of that possibility. You haven't talked about it today. And for me, I mean, it changes everything because the point of standards, one of the HDS is to have data available and usable in a certain way. And then, I mean, there's the role of standards that Francesca mentioned, Federica as well, with all the normative implications that it has. So, I mean, I imagine, my question is, can you tell us more about this possibility? Because when I asked him for details, he told me, oh yeah, health data access bodies, they can do processing. Processing can be anything. So they also have the possibility to clean the data for a fee. So that's the important part, is that a person would ask for the health data access bodies to clean that data. And then, can you please elaborate more on that? And for Francesca, for Federica, I have a question. Your point on SPEs, secure processing environments, being a gatekeeper, I think it's great. I have a question because, I mean, you painted it as, you don't get the data out of the system, it stays there. But in the case of AI, I mean, for me, I mean, the way I visualize it is that AI sucks the data in, integrates it in a model, and then we know that there are risks of data leakage and all of that. So wouldn't you say that's a good way? Because then there are provisions for, prohibiting re-identification of the data. Although re-identification is just one issue, it can be many other things linked to it. Could you tell us more about that? Thank you.
Just going to ask if you're going to collect first or if you answer right away. No. So, as part of the permit, one thing that could happen is that, okay, we're going to do some data preparation because, and maybe I'll seize on this opportunity to answer also some of the other questions or points that other panelists made. Because in secondary, we are not standardizing data quality as such. So we're not, basically we're opening up the mine, but we're not, here's the iron ore that you can then get the HDAP to, let's say, pre-process, but it's not that we're telling the hospitals you need to have the steel at the source. Linking this then both to standardization and the SPE questions a bit. For Federica, your point on where are the SPEs actually fit for purpose, and what happens if I'm in Italy and I know that there is this amazing SPE in Lithuania, which can do many of the things that I want to do and which maybe the ones that are in Italy cannot. So that is kind of twofold. One is the choice of the SPE, where that is in the permit, but you can have any SPE that meets the technical requirements. So you can also, as an Italian researcher, use them in the in that Lithuanian SPE, and linked to that on, do they have the right capabilities? Do they have the right tools? That is precisely why we also wanted to allow the private provision of them. Yeah. So to make sure that it's not just the one size fits some offering from the HDAP, but that other flowers can bloom, so to say, provided that they comply with the same standards. Sorry, I just piggybacked a bit there to say something slightly different.
And as for the AI system, if they can work within the secure processing environment, I don't know. Well, I'm really honest. It is true that the issue is exactly that. But one of the points of the European health data space is to, let's say, foster innovation, foster new research on this type of data. And the innovation and the elaboration of data is exactly pointed towards the use of AI, so developing AI system on the basis and training them on good data on accurate data, on quality data that are available across different countries, because they are, for instance, looking at the perspective that I realize it's important for the analysis that I'm doing. And you are perfectly right. This issue is that as soon as I have anonymous data, it's fine. Come on, they are anonymous at least. Let's take it that they are anonymous. There's a lot of unsaid there. But if they are anonymous, I can take the data and I can use them. But sometimes the anonymization does not work for the research, because I have to know, for instance, the gender, because my research is based on the different perspective and different reaction to pharmaceutical elements in a different way for women and men. And these data are coming from a single country and are used for a specific type of disease. Gender, geographical location, and type of disease. It's very easy to find out who are the people. So it's anonymization, but it's not. So the anonymization will conflict with the, let's say, with the results of my research, because that type of elements will be, let's say, erased from the data. And even more when I have pseudonymized data.
4 minutes left.
Yes. Okay.
I understand what was
Come on. So in the AI systems, it's even worse, because you will end up in having the possibility of hallucination, of re-emerging of the data. And in that sense, this is why the secure processing environment, at least so far, do not allow that type of activities. So one of the things that is seen is that it's not yet there. We don't have the possibility to grant for those who want to use machine learning, deep neural networks, and whatever type of elaboration that at the end of the day will end up in an AI system, is not yet there in terms of safeguards within the secure processing environment, at least so for what I know at the moment.
Okay, thank you very much. We have time for one last, yes. Yeah.
You can ask later.
Okay, if this is a short question, we can collect 2 short questions, and we can proceed with that. Okay, first question.
Great panel, thank you. My question was for O, about the interaction between the European Data Space and the European Open Science Cloud. Because the EOSC is not generally considered one of the European data spaces. It's a bit special, but they are very similar. The goal behind the European Data Space and EOSC they are necessarily connected. But the perception is that they are 2 separate silos without any kind of connection, or at least not a lot of connection. So I was wondering if there are some initiatives to coordinate, to avoid duplication of efforts, duplication of investments, or let's say to coordinate these 2 huge and ambitious projects.
Okay.
Thank you.
Then second question, short, please. They're going to explain from the room.
Yes.
Okay.
My short question is, in Holland, all the data subjects have the right to opt out.
Yes.
Isn't it the biggest challenge here to suppose a lot of people choose for an opt-out? That would undermine the whole purpose of the European health data space. I didn't hear anyone of the panelists about this. What do you think about that?
Audot spoke of this panel. I'm sorry, it's a big issue, so we decided to not cover this. Yes. But yes, it's a very good question, of course. So I don't know who can. Oh, I think probably you first.
I see I'm being put in the hot seat. A very short answer, comically short. So yes, that is a perception people sometimes have. Yes, we're working on it. So we're checking with them, seeing how to best integrate them. On the opt-out, yes, we're one panel, not one conference, so that's why we didn't have it here. The short answer on, so the very diplomatic answer is, well, that is what the legislator decided. We didn't have it in the commission proposal, but Parliament definitely wanted an opt-out. Council had a member state option for an opt-out, so you can, well, you can guess yourself how discussions went in the council. Some wanted one, some didn't. So the obvious conclusion for the council in the general approach would be to say, well, let's make that an option. That for the diplomatic answer. Now, for the commission answer, yes, that is indeed a risk. That is why we didn't have it in the proposal. And in terms of proportionality, the idea is that with all these safeguards around, so the process with the HDAPs, with the SPEs, with the allowed and forbidden purposes, that provides the safeguards to make this whole thing proportionate. But I mean, the question of the opt-out was kind of the biggest political issue in the negotiations. Yes, and this is the outcome that we have.
Well, thank you very much for your participation. Thank you for the questions. Thank you, panelists, for your very insightful presentations. A lot of follow-up questions. I don't know if we will have time for continuing this conversation, but thank you very much. And, well, a big applause, I think.